the initiation of a commission to investigate standards for peace officers. And therefore, it is certainly my honor and my privilege to present under the Speaker's program our guest today, Justice Stanley Mosk.
Thanks very much, Mr. Dean. Can you hear back there, or shall I use
Thank you very much, Mr. Levine and friends. I understand there was a little problem with the publication of the Daily Bruin coming out so late, and as a result, the Associated Students weren't quite sure how large or small a group they'd have here today. That reminded me of a story I heard Secretary of Agriculture Freeman tell one time about a problem along the same line. When he was governor of Minnesota some years ago, it seems that Jascha Heifetz was going to give a concert in a small town up in the northern part of Minnesota. And a few days before this event, there was a tremendous snowstorm that just inundated the whole area with about 10 or 12 feet of snow. So on the appointed evening, when Heifetz came out on the auditorium of the platform of the high school auditorium, there were 3 people waiting for him. So he looked them over and he said, well, now, instead of going through with the program, suppose the 3 of you come back to my hotel room and let's sit around, have a few drinks and talk and spend the evening that way. Well, the 2 of them agreed, but the 3rd fellow in the audience got up and he said, Jascha, he said, you just don't understand what I went through to get here. He said, I have traveled 150 miles. I traveled first 50 miles by automobile, then I abandoned it, took a train for the next 50 miles, and came by sled the last 50 miles. He said, it took me 18 hours to get here. It'll take me 18 hours to get back home. So, Jascha, please sing something, won't you? And, no, you're never quite sure of how large an audience you're going to have. My alma mater was the University of Chicago, and I was reading the address given to the Law Review banquet there last spring by Professor Grant Gilmore. And I was kind of so intrigued by his talk that I thought I'd start out by reading a couple paragraphs from it. He said, this seems to be the anarchist's spring. He said, this is the spring when all over the world people described as students have been marching with banners in angry protest against whatever is. This is the spring when all the people under 30 have decided that no one over 30 ought to ever be listened to, which must leave people who are just turning 30, like Professor Staunton Lind of Yale, in an immense hurry to say what they have to say before they cross the Great Divide and are never heard from again. He said, this is surely the spring when all the people over 30 have given up even pretending to understand what is going on. Then he continued, he said, my own generation in its youth went through what was then conceived to be a period of revolutionary ferment. And this, incidentally, was my period, too. He said, the Great Depression of the 1930s, which was our dearest intellectual possession, had taught us that society, it was not yet the Great Society, must be rebuilt. Wherever we clustered, from right to left of the political spectrum, we were all rebuilders. The one article of faith which no one questioned was that you must have clearly in mind, before you start the demolition, what you propose to put in the place of the structure you were getting rid of. There was to be no destruction just for the dreadful joy of seeing things go up in smoke, the awful ecstasy of seeing them come tumbling down in ruins. But this year, I take it, ideologies are for the birds, and we are all for the dreadful joy and the awful ecstasy. There was a French anarchist who, as he was being led off to execution, told his followers, if you want to be happy, hang your landlord. He said, there is much to be said for this, even from the landlord's point of view. It concentrates your mind wonderfully, as Dr. Johnson remarked, to know that you will be hanged tomorrow, and a short, happy life is on all accounts to be preferred to a long, dull one. Smash now, build later must be our slogan. And then he went on to tell the role of lawyers in this society, which he has described as the anarchist paradise. He said, "A wise lawyer once said to me that he had concluded after a lifetime of observation that all outstandingly successful men are insane. Their insanity is indeed their most precious asset. If they had not been insane, they would have been like the rest of us. The lawyer's function, therefore, when he counsels such a man, is to try to make sure that his client does not quite go off the rails without doing anything to curb the insanity which is the secret of his success. We are, all of us, by our profession, meaning us lawyers, the purveyors of reason to a world that is unreasonable, if not insane. We try to impose a degree of order on the swirling chaos. We perform a necessary, if somewhat disagreeable task. By our training, we come instinctively to prefer tradition, continuity, and ordered change. But let us bear in mind," he said, "that our true function is to preserve, protect, and defend the insanity which, while it terrifies us, is yet our greatest and our only hope." So that, in short, I suppose, is what at least some people think is the role of lawyers, and I assume also judges in this world today. Now, Mr. Levine, in his invitation to me, suggested that I might talk about the relationship between the judiciary and the electorate in regard to fair housing legislation. Now, I regret I can't talk about that, because since his invitation, the United States Supreme Court took over the so-called Proposition 14 case, granted certiorari. The case is now pending in the United States Supreme Court, and it's therefore highly inappropriate for me to talk about any pending cases. So let me begin my discussion today by telling you a story. Now, there's a lovely little garden city here in Southern California, which through fortuitous circumstances has become populated heavily by persons of Japanese ancestry. In fact, within the city limits, there are twice as many Japanese as all other residents combined. Now, these good, quiet people have been living in peace in that community since the close of World War II. They are decent, industrious, productive citizens. But recently, a chauvinistic mayor and city council were elected, preponderantly Japanese, and they were beset with space and zoning problems. And so an ordinance was proposed that declared that no building permits would be given to any Christian or Jewish houses of worship, that only Buddhist temples would be allowed to build within the city limits. And the ordinance was put to a vote of the people in that community, and being overwhelmingly of Japanese origin and Buddhist in religion, they passed that ordinance by a 2-to-1 vote. In order to make the ordinance effective, it was further provided that no Christian or Jewish religious services could be held unless the group first obtained a city permit. And these permits were denied indiscriminately, arbitrarily. Well, some people who wanted to worship according to Christian and others according to Jewish tradition moved into the community, and they sought to build first a Christian church, others tried to build a Jewish synagogue. They were denied permits in view of that city ordinance. And so they brought a lawsuit. They said it's clearly unconstitutional, the ordinance, because it violates the First Amendment right of freedom of religion. So, the city attorney said, this ordinance, he said, has been approved by the vote of the people, by a 2-to-1 vote. And the sovereign people, from whom all political and legal power flows, can pass any measure. No court has a right to deny the will of the majority. Well, at that point, suppose you were one of those who were trying to have some Christian or Jewish services in the community. You brought a lawsuit challenging the constitutionality of the ordinance. Now, what kind of a judge would you want to hear that lawsuit on this important constitutional point? Would you want a timid judge who would ignore the Constitution and, being fearful of retribution, would hearken to the election returns and say, why, the ordinance was approved by a 2-to-1 vote, that has to prevail? Or would you want a courageous judge who would, under the circumstances, disregard the views of the majority and decide the case solely on the basis of the religious guarantees in the First Amendment of the Constitution? Well, of course, this whole tale is fictional. No such community exists, and the problem could not possibly occur, or could it? Change the words freedom of religion to freedom of speech, and we have the pay TV case, known as Proposition 15. Here the people voted, over 2-to-1, that pay TV was to be barred in the state of California. California Supreme Court found that this measure was an invalid restriction upon freedom of speech, even though the people had approved the measure by a 2-to-1 vote. There was some momentary consternation about it, and generally, I think, afterwards, the press and the public recognized the issue and accepted the result. Well, now next, change freedom of religion and freedom of speech to the Equal Protection Clause of the 14th Amendment of the Constitution, and now we have the cases in which Proposition 14 was declared invalid. Now all hell breaks loose. Some newspapers, real estate associations, television commentators, assorted extremist political groups, and others well-meaning people immediately assumed a bellicose attitude and demanded to punish every judge who voted to thwart the will of the people. I personally didn't participate in the Proposition 14 cases because I'd expressed my views on it when I was Attorney General, and therefore I disqualified myself. Nevertheless, I was also the butt of the attacks upon the judges who did vote on Proposition 14. I was included in the denunciations, apparently because somebody read my mind and decided I wasn't thinking right. So a tremendous campaign war chest was raised from razor blade and dog food companies and other some other benefactors of exotic movements, and a campaign was launched to oust the justices of the Supreme Court, not because of incompetence or corruption, which the election process contemplates, but because the court refused to subordinate constitutional guarantees to election returns. Now, the normal no vote on, on judges in the appellate courts seldom exceeds 18%. Last November, after several $100,000 had been expended on a one-sided newspaper and radio campaign, the negative vote on judges rose to 38%. Thus, we may assume, I think, that 20%, the difference between 18 and 38, or 1/5 of the California electorate, believe the propaganda which insists that courts, in deciding lawsuits, are to evaluate public opinion and majority will in preference to the provisions of the Constitution of the United States. And so I want to suggest to you today that you, who I hope are the potential leaders of our society, and that those who are the present leaders, I think, have an educational process ahead of us to reach that 20% and to re-inculcate in those good people a renewed appreciation of the fundamentals of our constitutional system. Now, please accept my assurance that this transcends personalities. Individual judges are an insignificant phase of the problem, because most judges really don't care about the barbs that are directed at them in a campaign of this sort. I think it was Winston Churchill who once said, there's nothing in life so exhilarating as to be shot at without result. But the danger lurks in the effect upon our judicial system itself. If the day ever comes when judges are rebuked at the polls, not for incompetence or corruption, but for opinions that they render in good faith, if the day ever comes when judges must hearken to the voice of the multitudes in order to survive, if the day ever comes when a judge hesitates to march to the drumbeat of his conscience and chooses instead to listen to the crowd, yes, even when the crowd consists of the majority, on that day, I think our independent American democratic republic will have ceased to exist. Under our system of government, if a proposal does in fact violate the Constitution of the United States, then no vote of the people, whether it's a close vote, a 2-to-1 vote, or a unanimous vote, can render an unconstitutional measure valid. A vote of the people is no more effective in passing an unconstitutional measure than a vote of the legislature, if it is in fact contrary to the Constitution of the United States. Now, I concede that there can be a debate on whether a measure is or is not constitutional. But assuming that it is unconstitutional, then the mere fact that it was passed by a vote of the people rather than a vote of the legislature is wholly irrelevant. And since the days of John Marshall, the question whether a measure violates the Constitution is strictly a judicial problem, not one to be decided by newspapers, by television commentators, or even by popular vote. Now, I'm not, as I said at the beginning, I'm not going to go into the issue of constitutionality today because that is pending before the United States Supreme Court. But once again, let me assure you, you don't have to worry about the Supreme Court of California. You have my assurance that my 6 colleagues are persons who will never stultify themselves by ignoring constitutional guarantees and hearkening only to the ballot box. But my fear is what effect the vote might have on timid or indecisive judges at other levels who may fear reprisal and therefore be more inclined to hearken to what they believe to be public opinion rather than to the terms and provisions of the Constitution of the United States. The question was well put way back some 50 years ago by the only man in the history of our country who served both as Chief Justice of the United States and President of the United States, William Howard Taft, certainly no radical. He said, it is a complete misunderstanding of our form of government, or any kind of government that exalts justice and righteousness, to assume that judges are bound to follow the will of the majority of the electorate in respect of an issue for their decision. If the judges were mere representatives or agents of the majority to carry out its will, they would lose their judicial character entirely. And another radical by the name of George Sutherland, Justice Sutherland, said in 1934, if the provisions of the Constitution be not upheld when they pinch as well as when they comfort, they may as well be abandoned. Well, so much for that subject. I'm generally convinced that the courts of our nation have been leading the way toward achieving what President Kennedy once described as a world of law and free choice. And he urged at the same time banishing from the world a world of war and coercion. I think our courts have been leading the way toward this type of, toward achieving a land of law and free choice, based upon recognition of individual human dignity under our American system of government. Most serious questions, sooner or later, take the form of legal issues and reach the Supreme Court of the United States. During the years since 1953, when Earl Warren became Chief Justice, An extraordinary number of important problems have come to the High Court of our land. For example, it has had to decide whether under the Constitution segregation could exist among American citizens, whether all Americans should have equal representation in Congress and state legislatures, whether states or school districts may require students to participate in religious exercises in the public schools, how to achieve fairness in criminal trials by elimination of forced confessions, and whether everyone in a criminal trial has a constitutional right to an attorney to defend him, whether existing laws provide means to assure a free competitive enterprise system in America, and how to preserve the basic American rights of freedom of speech, press, and association. These and many other problems have come to the court since 1953, when what we now call the Warren Court began its existence. As a result, then, courts have been in the news considerably of late, generally the butt of querulous criticism. The tune may be new, but the theme is an old one indeed. Another radical by the name of Calvin Coolidge once had to defend the judiciary in his day. And he said, "It is not necessary to prove that the Supreme Court never made a mistake, but if the power is to be taken from them and reposed elsewhere, it is necessary to prove that those who are to exercise it henceforth will be likely to make fewer mistakes." Now, no court with big decisions to make has ever been popular with everyone, and certainly the Warren Court has been no exception. A decision would not be big if there were not some division among the people on the issue. The losers are disappointed, and generally they become bitter. Now, these days are certainly no exception. The wildest critics, of course, have been the John Birch Society, whose leader just the day before yesterday once again renewed the Impeach Earl Warren campaign. Well, I think the best answer to that campaign was in an editorial in the Los Angeles Times today. But in addition to the critics on the lunatic fringe, there are others who have had some genuine criticism, and some of it thoughtful criticism of the court. The critics, I think, can be generally put into four separate categories. First, there are the segregationists. The Supreme Court of the United States has, with relentless and unmistakable voice, held consistently that all Americans must have equal treatment and that no government can discriminate among its citizens on the basis of their race or color or religion. Now, these decisions have invaded the traditions of many states and of the established society in those states, and enforcement has resulted in perhaps the greatest civil strife since Lincoln's day. And inevitably, the segregationists have become very bitter critics of the Supreme Court. The second group of critics have been those who stand to lose political power under the redistricting cases. American democratic government assumes that people will have a vote that is equal to all others and be represented substantially equally. If this is to be achieved, election districts must have approximately the same population. This, of course, has not been greeted with elation in rural areas that in many states have dominated the political structure. The third group that has been critical are those who have been genuinely concerned about religion. In America, education is free, or relatively so until recently. But the frequent question has been whether it should also in some manner be religious. And the issue comes up in many ways. Can religious teaching be carried on in the schools during school hours? Can the students be required to recite either some nondescript prayer composed for them by someone in the state's education department or some great classic? Shall prayers be said in the schools at all? And always at the root of the matter, can tax money be appropriated for religious education? And finally, the fourth group that has been critical of the courts are those who believe that crime is running rampant because court decisions favor the criminal and handicap law enforcement. Now, before passing on to other topics, let me statistically demonstrate the fallacy of that old wives' tale that crime is running rampant because of court decisions. It may be that J. Edgar Hoover's recent statement put some of the fears to rest when he dismissed as extreme the view that courts are handcuffing law enforcement. Nevertheless, there are still court critics who cite statistics showing increases in crime, and they then attribute those increases in crime to court decisions. Now, it's true there have been court decisions on constitutional issues, and it is true that more efficient police work and more accurate crime reporting have resulted in crime statistics steadily rising. But the two facts have no relationship whatever to each other. That's like saying we're meeting here this noon and I had Wheaties for breakfast. Now, both of them are true, but they're hardly related. Now, bear in mind that crime statistics are based on the number of arrests, and arrests depend upon the effectiveness of police work. Figures go up, that means more crime, but it also means better law enforcement. But the effect of court decisions on crime and criminals is determined by the results after arrest. The test is not how many arrests are made, because that's purely police work, but whether defendants charged with serious crimes are now being turned loose. An analysis of this subject reveals that there has been no effect whatever upon criminal convictions by recent landmark decisions. In 1959, there were 22,939 convictions of felonies in the Superior Courts of California. 86.4% of all defendants charged with felonies were convicted. In 1960, the number of convictions rose to 24,816, representing 86.3% of all defendants charged. In 1961, the number of convictions rose again, this time to 27,960, or 86.9% of all those charged with felonies. 1962, 27,084 convictions, or 86.7%. 1963, number of convictions rose again, 28,393, or 86.3%. 1964, number of convictions was 27,830. And then last year, or 1965, we don't have the 66 figures yet. 1965, the number of convictions reached a new high, 30,840. Total of roughly 85% of all persons charged with felonies. And thus, from 1959 to 1965, the number of convictions of individuals charged with felonies rose by almost 10,000. Now, this consistent rise hardly suggests that court decisions have been a handicap to the administration of criminal justice. Quite the contrary, it indicates firm and severe justice is being dispensed in California today. It seems clear to me from these figures that our courts are more effective, deterring crime more vigorously, and convicting more guilty defendants than ever before in our history. And it's comforting that this is being done at the same time that our Supreme Courts in Washington and in California remain alert to the guarantees of the Bill of Rights bequeathed to us by our founding fathers. It will be a sorry day for America if demagogic politicians or hysterical commentators affect our American judicial process and persuade our courts to be any less concerned over individual constitutional rights. Now, I certainly don't mean to imply that courts, not even our court, is infallible. Contrary to some beliefs, judges are human. They make mistakes. And we know that lawyers and judges are among the first to admit their shortcomings. to concede errors, even to change opinions when conceded they're erroneous. If you'll forgive a personal reference, before going on the Supreme Court a little over 2 years ago, I served as Attorney General for nearly 6 years. During that time, I was responsible for nearly 2,000 written opinions. Now, inevitably, some of the problems in those opinions are going to come up to the Supreme Court, and it's just as inevitable, I suppose, that as a judge, I may reach a conclusion that's somewhat different than a conclusion I reached as Attorney General. Well, I did a little checking on and found that there's historical precedent for that. Robert Jackson, you may recall, served as Attorney General of the United States and later became a Justice of the United States Supreme Court. And he had to render an opinion as a justice that was directly contrary to one that he had written as Attorney General, and he felt obliged to explain it. So he explained it this way. He said, "The matter does not appear to me now as it appears to have appeared to me then." And Felix Frankfurter, who was one of our great justices, also one time wrote an opinion on the Supreme Court that was directly contrary to an opinion he had rendered just 5 years before. And he explained it this way. He said, "Wisdom too often never comes, so one ought not to reject it merely because it comes late."
Some of you have to leave for 1 o'clock. Would you please be so as quietly as possible? The justice will try to reach some conclusions, and then we'll break through.
Well, let me say that I'm going to wind this up very quickly. I think it would be ludicrous for anyone to suggest that medical practice today has to be bound by the theory and the practice of 50 years ago. Medicine is clearly advanced. And yet there are so many people in our society who don't understand that the judiciary and the legal profession cannot be reflective of the milieu of some 50 years ago. Law, like medicine, moves forward and as it adapts old traditions to new problems. And I think the public has to be alert to the fact that changes do take place, must take place, in the field of law just as it takes place in the other learned professions. Well, certainly I don't think I have to lecture to this group on a fact of this sort, but I do think that all of us have a responsibility to convince the unthinking public that that might need a refresher course in constitutional principles. Out of this vast society of some 18 millions plus in California today, I think perhaps an occasional reminder is necessary of the fundamentals upon which our nation was founded, and it might very well be helpful. This, as I suggested before, was particularly indicated by the campaign of against the judiciary of last year. In conclusion, let me assure you that while current courts may have been more noticeably active than their predecessors, they have been true, I think, to the historic role of the judiciary. It has been one of the genuine glories of American history that our highest courts in the state and the nation have been places to which come men gathered to deliberate on fundamental problems of the American people. One may not always be satisfied with the results, but still be grateful for the process itself. The fundamental triumph of our courts, from John Marshall to Earl Warren, has been the integrity of that judicial process. Anyone of an independent point of view will find what he believes to be errors in some portion of the court's work, and that's entirely proper, but he will find little that is ignoble. And it's for this reason that while courts may often be subject to hysterical attack, I think history will vindicate the American judicial process. Thank you.
On behalf of the associated students, I'd like to thank the Justice, especially for the very smooth way he handled the gyrations of the microphone and the speech, the table here, and the 1 o'clock classes. Let's break for a few minutes before we start our question-answer period. There's coffee refreshments in the back. Then if you have questions for the justice, please move up to the front.
Can I get you a cup of coffee?
Oh, all right.
You have to have, because last time we got our first copy daily rule. Oh, you have to have another copy that I could use.
Yeah, I'll give you one. Elected official who is sworn to take the oath to support the Constitution and the laws as they are and not as I would like them to be. And thus, while I have a view against capital punishment, I can still, as Attorney General, I fought to affirm capital punishment decisions of the lower courts, and as a judge, I occasionally have to write opinions upholding a conviction in a death penalty case. But if I were a legislator, I would vote to abolish capital punishment. I do not think it is a deterrent to anything, and I think it can be statistically demonstrated that it is not a deterrent to killings. For example, you take the state of Wisconsin that does not have the death penalty, and the state of Iowa right next to it that does. You'll find the ratio of homicides per 100,000 is identical. If you take Rhode Island, which does not have the death penalty, and Connecticut, which does, right next door to it, you'll find the rate of homicide per 100,000 is identical. The same thing with Michigan, which does not have it, and Ohio, which does. You can take any combination of states, those that do have the death penalty, those that do not, you'll find that there's just no difference at all in the ratio of deaths, violent deaths per 100,000. Then one other argument that's given against, in favor of the death penalty from time to time is that if you didn't have it, you had a light termer in prison, that the guards' lives wouldn't be worth anything because the person would kill freely and suffer no worse fate than he then had if he were in for life. And that sounds reasonable, but I checked with, when I was Attorney General, I checked with all of the states that do not have the death penalty: Michigan, Wisconsin, North Dakota, Rhode Island, Alaska, Hawaii, and so forth. And I found that they have no more homicides in their state prisons than we do. And as a matter of fact, many less. In the state of Wisconsin, for instance, they haven't had a violent death in their prisons since the turn of the century, whereas we have them frequently here in California, even though we have the death penalty. So it doesn't seem to be a deterrent. If a person is going to kill, they'll kill regardless of what punishment society provides. If the person doesn't want to kill, he won't, regardless of what society provides. Here again, I used to have some arguments and discussions with the late Chief Parker on this subject, and he used to say, well, but what you don't understand is how many times an armed robbery is committed with an empty pistol. The robber uses a pistol, but he doesn't have any bullets in it because he fears that gas chamber if he takes a life. Well, that's an argument, and I don't know how that may enter into the calculations of a robber. But I always felt it was just as logical to believe that this robber wanted to take somebody's property, but he still didn't want to kill a human being. That's just as logical, I suppose, as the argument the other way. So, the long and short of it is, I do not think it can be demonstrated the death penalty is a deterrent to crime.
Yeah, you were giving us statistics in the 20% increase of people who voted against the Supreme Court. I wonder if you know the statistics for the increase in those who voted in favor of it instead of not voting at all.
Yeah, well, those figures are the percentage of no votes to yes votes, so that it isn't the total. There were more yes votes than normal. That's true. More no votes than normal. And I'm talking about the percentage of no's to yeses. And percentage-wise, there was an increase from the usual number of 18%. In every election, 18% of people are going to vote no, regardless.
And this time it went up to 38. Well, I'd have to think about that, and my inclination would be that is not a wise limitation. Because I would say if you saw someone fleeing from the commission of a murder, that certainly a policeman ought to be able to shoot at him to stop him. Or if a person has committed any act of violence, I should think the law enforcement officer ought to be able to stop him using violent means if necessary. I'm not sure that's a good idea. Now, I do think on occasion that there's some bad judgment when violence is used to stop someone fleeing from a simple traffic violation or something of that sort. That's a case of just bad judgment. But I'm not sure that you can reduce this to a formula. Well, I think the answer is that in each instance the evidence was sufficient to support the verdict. Now, one thing that I think we always you have to bear in mind is that a reviewing court, whether it's the Supreme Court of California or the Supreme Court of the United States, does not review penalty. If a person is convicted and is sentenced to state prison or given the death penalty, the court does not review and has no power to review or change the sentence itself. It has only the power to review and ascertain whether the man A was properly convicted and with due regard for his constitutional rights, and B, whether the evidence was sufficient to justify the judgment of guilty. But the court has no power to change the sentence itself. No, I didn't say that the unconstitutional should not be put to vote. As a matter of fact, up at the present time, there is no way to ascertain whether a measure is or is not constitutional until after it has been adopted and until someone is affected by it. That, I think, might be changed, and it might be wise to consider ways of changing that so that there is a definitive determination of constitutionality before the people are put to the travail of a campaign and the passing of a measure. But up to the present time, courts have been understandably reluctant to determine constitutionality until after a measure has been adopted and is on the books. Yeah. Yep. Well, I don't know. There have been suggestions that some sort of computers, data processing might be used in the field of law, but for the life of me, I can't see how this can take place because in most instances in a trial, whether a civil trial or a criminal trial, you have an issue of fact. One person says this took place, and the other person says this did not take place. So it becomes a question of veracity. Now, how a computer could determine that is just beyond me. That's basically the problem. Now, I don't know how you could feed information to a computer that would decide that. Take the bulk of your civil cases today are personal injury cases. They're automobile accidents that happen at an intersection. The question is, which party was negligent? Or were both negligent? Now, how can a machine ascertain that question of fact? Now, if it is purely a question of law, the facts are admitted, then it is conceivable that a machine could have been fed enough information on law and precedent beforehand to come out with the answer and you push the right button. But I don't know how a machine can determine questions of facts or questions of veracity.
There's been renewed controversy in Great Britain about the changing of the jury from a unanimous decision to some form of percentage. What would be your opinion on any moves in this country to change, for example, and especially in criminal cases, the current unanimous vote to say the proposed 10-2 as being the cutoff point?
Well, of course, we do not require unanimous decisions in civil cases now. Civil cases may be decided 9-3, but criminal cases do require unanimous verdict, and I'm inclined to think that's best. There are remarkably few cases out of the hundreds of thousands tried every year where there's just one lone holdout among the 12 jurors. And I don't know how we can say that one person's judgment is no good under the circumstances of other jurors. I would be inclined to think our system would prevail. Now, there are certain moves to cut down on the number of jurors in civil cases. Some people suggesting perhaps the 6 might be enough in a civil case, thus shorten the process of selecting jurors, cut down on the trial time that way, and I think that deserves some consideration. Well, won't you always have that regardless of how many jurors you have? Perhaps. That's a reasonable point of view. Well, last a little over a year ago now, made a tour for the State Department to lecture at some of the new law schools in Africa. And there are quite a number of fine new schools. Good one in Addis Ababa in Ethiopia, and one in Tanzania, one in Sierra Leone and the West Coast. And made sure of them. I don't have any particular observations. I was lecturing to them on the Southwest Africa case, which was then pending before the World Court. Of course, that has now been decided. And court decision stands by close 8 to 7 votes.
First, I'd like to hear you on the technology. And then, specifically, last month was a fellow who's convicted for 2 years of advising an undercover where he could obtain marijuana. That penalty in relation to the total penalty for marijuana and also a comment on criminal
A, B, and C, all of these. Well, I assume there are many non-lawyers or non-embryo lawyers here. The Hallinan case was a case of a young man who had passed the state bar, but the Board of Bar Governors refused to certify him on the ground that his past conduct indicated he lacked the moral character required of a member of the bar. This on the basis of some of his civil rights activities, that he had been arrested several times, and also his propensity for violence. He had been engaged in, he had had a series of fights over a period of years with his contemporaries, and some of which wound up in court, probably in court. All I can say is that the Supreme Court re-evaluated the findings of the Board of Bar Governors and reached a different conclusion, to wit, that while he had engaged in civil rights activities, while he had been particularly active in some sit-ins, one of them in violation of a court order, while he had engaged in some fights, that overall this did not indicate a lack of moral character required of a member of the bar. Of course, this evaluated the facts and reached a different conclusion by a 6-1 vote. Criminal syndicalism? Well, I've never been enamored of the criminal syndicalism statute. I don't. They haven't been applied in recent years. Well, the penalties for narcotic violations, of course, have been increased several times in recent years. I find it difficult to comment on particular penalties for particular offenses. This is strictly a legislative matter. But let me just say that philosophically, I don't believe that you solve a criminal problem merely by constantly increasing penalties. This is too easy an answer. A certain crime is being committed, or the numbers of crimes in a particular field increase, and there's often a public demand, or apparently a public demand to let's increase the penalties. The penalty was 1 to 10, let's make it 2 to 20. But that very seldom stops the offenses. If that were so, I suppose we might as well have the death penalty for everything, and we'd stop all crime. I think the best type of punishment is certain punishment rather than severe punishment. If everyone who contemplated the commission of a crime were certain that he would be apprehended and punished, I don't think it matters very much whether the punishment is 1 to 10 or 2 to 20 or 5 to life. as long as there is a certainty of punishment. That seems to me is a better answer than the severity of punishment.
I often wonder how far afield say the Supreme Court can go in the interpretation of the law. For instance, the proposed legislation of firearms. In the Constitution, we have the right to keep and bear arms. At the same time, the proposal is to almost do the opposite of that, to limit.
Well, if you read that constitutional provision again, it doesn't guarantee an individual the right to keep and bear arms. It provides for a well-regulated militia as necessary. And the regulation by states of bearing of arms, concealed weapons, has been upheld. Now, there can be no regulation of an individual's right to have weapons in clear and plain sight. You can walk down the street with a gun over your hand and your shoulder. It's not a concealed weapon, and this is your absolute right to do so. But it's the concealed weapon that can be prohibited, and I think heavy weapons can be too. I have always felt that the Dodd bill, providing for regulation of interstate shipments of weapons, is a good measure. As the law now stands, a minor can acquire a weapon through mail order. He can write to S. Klein and Company in Chicago, order of any kind of a lethal weapon, have it delivered in a fictitious name to a post office box, as one Lee Harvey Oswald did. This can be done by a minor, it can be done by a criminal, it can be done by a subversive, it can be done by an alien, it can be done by a mentally ill person, it can be done by any of those persons with no restrictions whatever. It just seems to me that society is not well protected when this is possible. I think laws can be devised that would give ample protection to law-abiding citizens who want to acquire weapons, or to sportsmen who want weapons for hunting without any limitation at all. But when all of these categories can acquire weapons with no difficulty whatever, it seems to me some regulation is indicated. I think the best example of what our laws presently permit is, you remember 2 years ago when Director of Finance Hale Champion was kidnapped from his home, and he was being driven by the kidnappers in a car over Northern California, and they stopped with the kidnapped man in the car, and they stopped, and one of them went out and purchased a gun at the very time they had the kidnapped victim in the car outside with no identification at all. They were combing the countryside for this man. He walked in, bought a gun, and bought ammunition just as freely as that. Well, this isn't right.
Regarding to the weapons issue, I wonder how feasible it would be to raise a great tax on weapons so that it would become very difficult for people to buy these weapons, and that way you could also raise revenue, which Regan is starting to worry about.
Well, of course, there's a fundamental problem there. I'm not enamored of the idea of taxing a commodity out of existence. If the commodity is wrong, let's ban it because it's wrong, and not merely impose a confiscatory tax on it. Because if you do, then only persons of wealth can acquire that commodity, and maybe they're no more entitled to have it than persons of limited means. So I'd rather face the issue squarely rather than to put a confiscatory tax on it.
We'll have time for a couple more questions.
I wonder if you'd care to make a few more comments on the general relation between the Constitution and the changing will of the people. For example, and that's right, of course, by calling majority high school students students of the Bill of Rights. It seems to me it's not going to satisfy who want to do away with the right to exist freely. So they want
Well, I share your apprehension about the understanding of the Bill of Rights. Earl Warren made a speech to the American Bar Association in St. Louis a couple of years ago, in which he said that if the Bill of Rights were up for ratification by the people today, he's not sure that it would pass. This is a frightening thing. I think all of us want freedom of religion, but generally we think of freedom for my religion, but not for yours. And we think of freedom of speech for me because I like what I'm saying, but not freedom of speech for you with whom I disagree. And this, I don't think our educational process has made very clear. I don't think that we're as well grounded in constitutional principles today as we ought to be. Now, where the fault lies, I can't say. I don't know whether it's the fault of our public education system or the fault of our media of communication, the press and television, that perhaps could do more in that area than they do. I don't know. I don't know quite where to assess the blame, but I do share the apprehension that there isn't quite the understanding of principles that there ought to be. Well, you've asked me. Who hasn't asked the question?
I'd like to ask about the concept of laws against acts against oneself, as opposed to acts against society. Like numerous laws, like sexual laws and narcotics, are really laws that prevent behavior which is not directed against others in society, but solely to oneself. How does this enter, from your view, into a constitutional issue and philosophical?
Well, that's a very good point, and I think there is some soul searching in that area among in legal institutions today. The American Law Institute, for instance, has suggested in the field of sex deviation, that there ought to be some changes. They are recommending that some of our laws on homosexuality are antiquated. They are suggesting, for example, that there ought to be no ban on what two consenting adults do in the privacy of their home. And there's something to be said for that. It seems to me clearly that what one does in public is of concern to society because it affects persons who certainly don't want to observe those activities. If activities involve a minor, this is of grave concern to society. If any force or compulsion is involved, this is of concern to society. But what two consenting adults may do in the field of sex activity in the privacy of their boudoir seems, as you have suggested by your question, may be of little concern to society. Yet our laws still say that certain sex acts are barred, even if committed between husband and wife. Now, as I say, the field of law, American Law Institute, and agencies of that sort are re-examining that and suggesting changes. The model penal code does include that particular change. The state of Illinois has recently adopted that, and England has recently adopted the concept that there can be no punishment for homosexual activities between two consenting adults in privacy. So there is some thought on that subject today.
This will be the last question.
All right, who hasn't asked one?
I have.
All right.
Well, there exists certain discriminatory practices the police in regard to parking. They seems like students get parking tickets and yet Westwood residents do not. They listen to it. Now, what can be done about that?
Well, of course, violation of the law is violation of the law, regardless of whether it's done by a student or by anyone else.
Well, the Cadillac and all those. You know,
I really don't know what the practices are. I used to live before I was on the Supreme Court, I lived in Westwood, right over in Warner Avenue, and we couldn't park in front of our own home because there was a no parking sign there. They weren't treating us as a resident any differently than they were treating the students at that time. Maybe things have changed.
On that light note, I think for the last time we would like to thank Justice Mosk for appearing here.